It's a broad area. It's an increasing area of the law. There are a lot of discussions happening in the United States and with Europe and with other countries. The one thing I'd recognize for you folks, especially since I assume some of your clients are in Texas, is that Mexico just enacted within the last month or so the equivalent of the European Privacy Directive. So to the extent that there might be data located in Mexico that may be relevant to U.S. litigation and it involves personal information, we may well find ourselves in the area where a federal court in the United States has to decide whether to require a party to produce information that it has in Mexico.
That's interesting,
It's a very
Ron,
fascinating issue, Julie.
It is, and with Mexico enacting that directive relatively recently, very recently, it will also bring up issues that we've dealt with the European Union Data Protection Act for many years, which is, does the production, if it occurs within the United States, then waive privilege for a non-party in subsequent litigation? So I'll be interested to see how this area of law evolves in regards to Mexico's directive.
Well, stay tuned. As I say, I think we're going to be seeing a lot more developments as we go forward. And with that, maybe we should spend a little time on preservation and spoliation, and that brings us to slide number 8, or my case number 8. This is a decision from the Southern District of New York, again from March of this year. It was an action to recover on a promissory note. The plaintiff moved to have the defendant held in contempt and for sanctions based on Rule 37 of the Federal Rules of Civil Procedure for failure to comply with discovery orders. ESI that had been subject to those orders had been stored on a flash drive, which allegedly failed and had been discarded. And the court goes on, and I'm going to discuss another case that it relied on, found the defendant grossly negligent in failing to have copied the drive before it failed. And the court also rejected defendant's reliance on something called Rule 37E of the Federal Rules of Civil Procedure. That's the so-called safe harbor rule, because the information wasn't lost to any, quote, routine, close quote, computer operation. The reason I have this in here is just because it raises the question of a preservation hold being in effect, Julie, and something happening to hardware. If you read the decision, there's a lot more to it than a simple hardware failure, but I raise it for the question of whether or not, if you're subject to a litigation hold, there's some obligation to do some type of spot checking to make sure everything stays preserved. The consensus seems to be, as a general proposition, no, you don't really need to spot check. But the opinion has language in it that's pretty broad. And I just throw it in here as, I don't know whether you want to call it an outlier or something that's really fact-dependent, which it certainly was in all these things, for people to think about if they're subject to a preservation hold, what you need to do. And Julie, I expect there's a lot we could talk about this if we want.
I think we could spend a whole hour on this one, so perhaps we should move on to slide 9.
Okay. I mentioned before to you, one of the suggestions under the Duke Conference was the creation of some type of uniform rule that would be addressing preservation and spoliation. These 3 decisions you have in front of you are examples of different approaches that courts are taking to the question of spoliation. I just mentioned the Wilson case to you in number 8. Wilson refers to this pension committee decision. Pension committee was decided by Shira Shinlin, one of the leading writers, judicial writers in the country, on electronic discovery or discovery of ESI. And pension committee is about a failure of a number of plaintiffs to preserve certain information. We could spend 15 minutes going over the factually. This opinion's, I'm not sure what the page count is, but there's a lot here.
80. And, I believe it was 80 or 81.
And it comes in the context of law from the Second Circuit, which says that if a party is negligent or grossly negligent in not preserving information, there can be some severe sanctions imposed against the party. If you read pension committee, you'll see that the judge found, as to some plaintiffs, that they were grossly negligent in failing to do things, that they were negligent in failing to do things, and Judge Shinlin crafted adverse inferences against parties depending on their level of culpability. Rimkus, is a decision out of Houston from the Southern District of Texas, written by another leading writer in the area, one of the leading jurists in the country, frankly, Lee Rosenthal, a district judge. And if you read this decision, you're going to see, again, it's a long one. But one reason why it's long is because Judge Rosenthal takes a little time to talk about different standards that exist among the circuits. The judge is in the Fifth Circuit. The Fifth Circuit requires a showing of willfulness. Pension Committee in the Second Circuit does not require willfulness for the imposition of sanctions. And you see a split between two circuits as to how you approach the elements needed for spoliation. Victor Stanley is here. Victor Stanley's new decision came out within the last several weeks, written again, or written by Paul Grimm, whose name we've heard before. Victor Stanley is a decision where the defendant, and if you read the decision, the facts are pretty bad, engaged in willful and intentional conduct. Judge Grimm spends a lot of time in this opinion. I commend it to anyone who's interested in seeing the way circuits approach sanctions, and talked about the need, or not the need, but perhaps the usefulness of a national standard or uniform standard among the federal courts for the imposition of sanctions. Interestingly, one of the things he does to the individual defendant here is say, you know, you need to produce information in order to produce the information. And Judge Grimm recommended that the defendant be held in civil contempt and that he be imprisoned for up to 2 years until he complied with discovery orders. So you see between these decisions different ways to approach sanctions, different standards for sanctions. Victor Stanley, you see an exhaustive discussion, and it is a long discussion, of the way sanctions are approached in various circuits in the federal court system. And I'd also commend to you an attachment to the opinion. It's a chart, I believe, about 12 pages long, that again summarizes the approach that the circuits have taken to spoliation sanctions. Julie, again, this is something we could spend an hour or two talking about.
I agree, and being from Texas, I enjoyed reading Rosenthal's opinion in Rimkus and was interested to see a bit of rub between the decisions, between what Judge Shinlin pertained to be a sanctionable act as opposed to Judge Rosenthal.
Well, remember, first, we're looking at the level of the intent of the person who spoliated or who didn't keep things. There's a difference between the Second and the Fifth Circuit in that area. And also interesting to me are the type of adverse inferences that were crafted. Judge Rosenthal's adverse inference instructions need to be crafted or compared to those that Judge Shinlin set forth in Pension Committee. And it's really a question of exactly what you're going to tell the jury, what the jury, if anything, can presume, and what kind of fact-finding a jury has to do. So there is a lot going on here. I mentioned that there may be some activity within the Judicial Conference of the United States to craft some type of rule that might be designated or might be used nationwide to try to avoid the variation in standards. And I have spoken to people who might represent corporate entities or may be with corporate entities who recognize that one of the challenges they have now is the fact that they may be a litigant in more than one place in the United States, and the standards may be different. The standards may be a little different for when a trigger happens, a trigger being the event that requires you to impose a litigation hold, and also there may be some variation into what sanctionable conduct might be. So there's a lot here. Stay tuned. Look to the Administrative Office of the United States website if there may be some suggestions about rulemaking and the like, but we're far in advance of anything happening. That usually takes a few years to have a proposal out there, to have it eventually adopted by the Judicial Conference, proposed to the Supreme Court, adopted by the Supreme Court, subject to some action by Congress to perhaps not have an amendment go forward. And with that, maybe what we should be doing is leaving the world of sanctions after we've just gotten everybody scared and move on
and
to
moving on to employers. Two decisions here, and the New Jersey decision here is from the New Jersey Supreme Court.
I'm from New Jersey, and I chose this as obviously a jurisdiction that's of particular interest to me. But these 2 bullet points address different things, really. City of Ontario is a decision that comes out of the federal courts in California, goes to the United States Supreme Court. And there's a question here about the Fourth Amendment rights of employees. If you're a public employee, because your employer is a public entity, you as an employee are entitled to certain rights under the Constitution, one of those being the Fourth Amendment right to avoid unreasonable searches and the like. And I'm not going to go into too much detail. This is another 15 or 20-minute discussion that Julie, you and I could have if we wanted to. But really what happened is the Supreme Court says there's no Fourth Amendment violation here. First, we're going to assume that Kwan, who is the officer who was disciplined here, had an expectation of privacy. But on the other hand, the city had a legitimate interest in looking at his ESI. And by the way, we're talking about text messages on a pager. And they went into the pager, they did a reasonable search, they found information, and that he approves him being disciplined. Really interesting because the Supreme Court had an opportunity to say a lot more in the area of the Fourth Amendment. I think there was an expectation by a lot of commentators that the Supreme Court would do that, and the Supreme Court punted just to address the issue before it. StenGuard's the flip side. StenGuard is a private entity, loving care agency. Mrs. StenGuard thinks she's being discriminated against. She uses a private email account of hers, and I believe it was Yahoo, but she Yahoos her attorney or emails her attorney over the employer system. So in other words, she's sitting in the office, sends email to her attorney. During the course of discovery, some of her email turns up in answers to interrogatories or production by the defendant. It turns out the defendant's attorneys had looked at the email that Ms. StenGuard sent, and they used it in the litigation. New Jersey Supreme Court says, number one, there's an ambiguity into what an employer or employee can do using employer communication systems. There's an ambiguity. Generally, you resolve it in favor of the other side, and here Mrs. StenGuard.